ICTY, and the International Criminal Tribunal for Rwanda, or the ICTR, as well as the extraordinary chambers in the courts of Cambodia, which I'm going to call for short the Cambodia Tribunal, because that's a very long name, and the Special Tribunal for Lebanon are all part of an interlinked network of international criminal justice. Today, I would like to explore what has happened over the past year through three themes: review, cooperation, and closure. Under the theme of review, I'm going to talk about, of course, the review conference of the International Criminal Court that happened in June in Kampala, Uganda. But in a different sense of the term, I'm going to also look at review or scrutiny of the Special Tribunal for Lebanon, which is a tribunal that we haven't really talked a lot about in these international humanitarian law dialogues. In focusing on cooperation, I'm going to explore the contradictions in state cooperation and individual cooperation with these different tribunals, and also non-cooperation with these tribunals. And finally, in looking at the theme of closure, I will discuss preparations that are in place for the impending closure of the Special Court for Sierra Leone, as well as the later closure of the ICTY and ICTR. So turning now to the theme of review. As all of you know by now, the review conference of the ICC was held on the shores of Lake Victoria near Kampala, Uganda, from May 31st until June 11th of this year, so it was relatively recent. The main event, of course, was the discussion on the crime of aggression. Now, I'm not going to get into this discussion on the crime of aggression because we discussed it all day yesterday, but I can tell you that from the point of view of a law professor, I thought it was difficult to explain the jurisdiction of the International Criminal Court before we added the crime of aggression, but now that we've added the crime of aggression, it's going to take an entire class to explain the jurisdiction of the ICC, but it will probably make for a really good exam question for the students. All right, so Kampala Review Conference. I was there as part of the Canadian delegation, but I was also there with funding to study the gender issues that arose in the review conference. There are a couple of you, Professor Shade is back there and Professor Sadat, who were there. You might be saying, what gender issues are you talking about? Well, I'll explain in a minute. At the International Criminal Court Conference in Rome, when we adopted the statute, the gender issues were very obvious. For example, there was intense and long and late night discussions on the crime against humanity and war crime of forced pregnancy, how to define that particular prohibited act. As well, there was discussion on the inclusion of provisions on the elections of judges, as well as the selection of officials and hiring of staff, because some of them needed to have expertise on crimes such as sexual violence. We also had very intense discussions in which I was directly involved as a member of the Canadian delegation on the definition of the term gender, which was included in the Rome Statute. And it's particularly important because there is a crime in the Rome Statute called gender-based persecution, which is a crime against humanity. And lastly, there were discussions of gender issues that surrounded various victims and witness protection issues and how to incorporate those into the Rome Statute. So, for example, when girls and women come to testify about having been subjected to sexual violence or sexual mutilation, how can we best not re-traumatize them in appearing before the ICC? And these were lessons learned from the ICTY and ICTR that we incorporated into the statute of the International Criminal Court. Okay, so that was back in 1998, and it was clear what the gender issues were. So it was clear what my job on the Canadian delegation was in focusing on gender issues. But in Kampala, we were discussing the crime of aggression. We were discussing adding the war crime of internal armed conflicts, of using poisonous gases in internal armed conflicts. So where are the gender issues in that? Well, the Rome statute system on victims and affected communities. As well, we were looking at cooperation, complementarity, and peace and justice. So the gender issues actually came out most strongly in the stock-taking exercise on the impact of the Rome statute system on victims and affected communities, as you might expect. So let me just outline a few of the themes that emerged in that stock-taking exercise and in the preparatory documents that accompanied that exercise. So the first theme that emerged was the importance of protecting intermediaries. These are individuals who help the International Criminal Court access the victims in the field and reverse, the victims accessing the International Criminal Court. So these intermediaries can be very, very important. And this is especially the case when it comes to girls and women who have suffered sexual violence and who, if they reveal it to the larger community, could be ostracized or stigmatized. So they need to be very careful who they speak to. Or if it's already well known, then they might be being supported or helped by a particular women's organization, supporting them through what they have experienced. So the ICC makes contact with the organization, and the organization helps to identify potential victims and witnesses in the field. So these intermediaries are very, very important. The second theme that emerged from this examination of victims' issues in the ICC is the challenges of the ICC in getting sufficient information about the court to women. One of the most telling stories that I heard at the Rome conference was from someone who was trying to get information out to women who had suffered sexual violence in the Democratic Republic of the Congo. One of the ways that the International Criminal Court gets its information out is through a radio program. But what happens in many of the households in the Democratic Republic of the Congo is that the man takes the radio with him during the day. So the women of the household don't have access to the radio programming that goes on during the day, and sometimes not even in the evening either. So they're not hearing the radio programs from the International Criminal Court, and they're not getting information about the fact that they can sign up to be represented as a victim in certain of the cases. The third theme that emerged in the stock-taking exercise on victims' issues is the need for the International Criminal Court to effectively manage victims' expectations of what the court can do for them. You can imagine the International Criminal Court goes into the field, and individuals don't really know what this court is about, but what they're hoping is that the court will not only bring justice, but it can get them housing, medical treatment, and these sorts of things. But this is not what the court can do. So the ICC needs to manage these expectations, including amongst victims of gender-based violence. The fourth theme is the need for the ICC to improve its two-way dialogue with victims. The International Criminal Court has within it a very different way of dealing with victims' issues than the other tribunals do, in that victims have their own legal counsel. So there are more than two parties in the ICC. There's not just the defense and the prosecution. There are also victims and the victims' counsel. So it's been a learning process about how to integrate these victims' views into the ICC process, and the consensus is that it's a good start, but we need to improve that two-way communication and dialogue with the victims. And the fifth and final theme that I saw emerging from the victim stock-taking exercise is the need for states parties, the states that have ratified the International Criminal Court statute, to cooperate with the court so as to better protect victims, including victims of gender-based violence. Now, I wanted to mention here that the stock-taking exercise also prompted a number of side events. So the stock-taking exercise involved all of the states at the review conference, as well as others who were there. But there were also side events that were not considered as official on the program, but these delved very, very deeply into victims' issues, and I think that they were probably for me anyway, someone looking at gender issues, one of the most important parts of the review conference. And here we have expert organizations like the ICC's Victims Trust Fund, Redress, DOMUS, the Women's Initiatives for Gender Justice, and many, many others delving into the details of victim protection that could not have come out in the wider state discussions. So this was really, really important. And also a number of organizations issued reports and analyses that I think advanced the discussion quite a bit. And it's going to take some years, actually, to think about and integrate all of these different ideas and suggestions that came out of the various expert reports. So through the lens of gender issues, which is what I focus on, the victim stocktaking and the related events were the most successful in bringing gender issues to the surface of the review conference. There was some mention in the other stocktaking exercises on peace and justice, cooperation, and complementarity, but not as much. But what about aggression? Aggression can in fact be an incredibly and profoundly gendered experience. For example, in Rapp's invasion of Kuwait, Kuwaiti women and girls were specifically targeted by Iraqi soldiers for rape. And this is a gendered experience of an aggression. In Kampala, the gendered nature of aggression did not come up. And in fact, it didn't come up either, as far as I can recall, in all the years that I've been involved in the aggression discussions. Where it did come out in Kampala was in a non-governmental side event, which was an all-day women's court held on June the 1st, where women came from all over the world and testified about their experiences of aggression, crimes against humanity, genocide, and war crimes. And in those testimonies, women talked about the gendered nature of aggression as well as the other crimes. Now, it's not surprising, I think, that the states did not discuss the gendered aspects of aggression at the review conference or even perhaps earlier. But what is more important, or most important, is that when the ICC prosecutes the crime of aggression in the future, it will need to examine the gendered aspects and effects of this crime just as it does for genocide, war crimes, and crimes against humanity. Now I'd like to turn to a different type of review, and that is a review or scrutiny of the Special Tribunal for Lebanon. This is a relatively new tribunal. It's the youngest tribunal of the different tribunals that we've been discussing. And it is one that was set up after the 2005 bombing death of the former president of Lebanon, Rafik Hariri. It's a different kind of tribunal in that it's not focused on genocide, war crimes, or crimes against humanity. It's focused on terrorism. And it's one of the reasons why it's under a bunch of scrutiny is because it has issued no indictments and it has no cases ongoing at the moment, and it's been in operation for over a year. So you might be wondering, what has it been doing this past year? It doesn't have any cases yet. Well, the president of the tribunal, that's the chief justice of the tribunal, issued in the spring a report, and in it he outlined the various activities that the court has been doing over the past year. So I'll just give you a sense of what the court has been up to, even though it has not been actually prosecuting particular cases yet. So let's look at the judges. The judges spent the year building the legal and regulatory framework in which the eventual prosecutions can take place. So for example, they drafted the rules of procedure and evidence. They also negotiated agreements with entities like the International Committee of the Red Cross, so that when eventually individuals are in detention and are being tried, and then eventually perhaps being convicted and serving prison sentences, the ICRC will visit the detention centers and the prisons to inspect the quality of them. The registry. The registry devised a court management system over the past year and signed a memorandum of understanding with Lebanon regarding a Beirut field office. I should mention that the Special Tribunal for Lebanon is based just outside of The Hague. It's not based in Lebanon for security reasons, but it does have a field office in Lebanon. It also built a courtroom, a library, and hired staff. So it was building up. The Office of the Prosecutor, this is the part of the court that is under the most scrutiny. And it continuously has put out press releases indicating that it is investigating the attacks falling in its mandate. It sent more than 240 requests for assistance to Lebanon and 60 other countries as well. It did over 100 investigatory missions, and it interviewed over 280 witnesses. So it has been active. This tribunal is also different from the other tribunals because it has another organ, a separate organ called the Defense Office. And over the past year, the Defense Office has been also creating its organizational structure, making lists of counsel that will be available once there are arrested people who need counsel. Who may not have enough money to pay for their own lawyers. So, as of now, the Special Tribunal for Lebanon has 276 staff and a budget of 55.4 million euros. Now, I just mentioned that the prosecutor has been under a great deal of pressure over this past year. Where are the indictments? He keeps getting asked, where are the indictments? And he has issued press releases periodically saying things like this. I'll just quote the most recent press release, which was about a week ago. The prosecutor will determine when and against whom an indictment will be issued to the pretrial judge for confirmation. However, no indictment will be issued until the prosecutor is satisfied that, in light of all of the circumstances, it is based on solid and convincing evidence. So that's the status of the Special Tribunal for Lebanon at the moment. And I'd like to turn to my second theme, which is cooperation. The theme of cooperation by states, by individuals, and by regional and international organizations is at the very heart of international criminal justice. If we didn't have cooperation by states, by individuals, by international and regional organizations, we wouldn't have a system of international criminal justice. So we saw in the past year many examples of cooperation and many examples of non-cooperation emerging. And I'm going to look at both. But let's start on the positive side with cooperation. I'd like to begin by taking a look at the Cambodia Tribunal. You heard yesterday from the prosecutor of the Cambodia Tribunal about the Doi case. Doi was the first person to stand trial before the Cambodia Tribunal, and he had served as deputy and chairman of S21, which was a detention center that operated between 1975 and 1979 that specialized, unfortunately, in the interrogation, torture, and execution of at least 12,000 people who were considered enemies of the Communist Party of Kampuchea. During the trial, and I don't think the prosecutor mentioned this yesterday, but during the trial, Doi was very cooperative. He, in fact, explained the inner workings about the operation of the prison and explained things that we didn't understand until he set them out for us. The international community and Cambodian community knew some, but not all of what he had to say. So he really shed light on the operation of S21. He also apologized repeatedly to the victims. You heard from the prosecutor yesterday about how the public gallery was full almost every day. 28,000 people over the course of the trial watched the trial, and he was apologizing to the victims and to them during the trial. But very oddly, in the final days of his case, he did an about-face and then started to argue that he was simply acting on the orders of others and that he should be acquitted. On July 26, the trial chamber of the Cambodia Tribunal found Doi guilty of crimes against humanity and war crimes. He was sentenced to 35 years of imprisonment. The trial chamber found that he showed a high degree of efficiency and zeal in carrying out his functions. He liked what he was doing. Based in part on his cooperation, though, they did not give him a life sentence. and they discussed this. They said instead, they were giving him 35 years, which they then reduced by 11 years for the time he'd already spent in pretrial detention, and then again by another 5 years because his pretrial detention was longer than what was allowed under Cambodian law. Something that the prosecutor didn't mention yesterday is that the chamber also ordered the compilation and publication of all of his apologies during the trial, so that it would be very clear to the Cambodian public that he apologized to the victims during the trial. Also, in the judgment, they ordered that 66 of the 90 victims who applied to be civil parties will have their names and relationship to the prison included in the final judgment. Now that judgment is currently on appeal. The Cambodian Tribunal, turning now to the theme of non-cooperation, operates in collaboration, in partnership with the government of Cambodia. And yet that same government has demonstrated non-cooperation with the tribunal. The Open Society Justice Initiative, which is an organization based in New York, released a report in July providing compelling evidence of political interference by the Cambodian government in the Cambodia Tribunal, including pressure on Cambodian officials not to investigate certain well-connected Khmer leaders. This is disappointing, though maybe not surprising. But in response, the United Nations Secretary General has appointed a UN special expert on the extraordinary chambers in the courts of Cambodia. You heard that yesterday, it's Clint Williamson. And the hope is that apart from helping facilitate funding and this sort of thing, that he will also help to curb this political interference. Turning now to the ICTR. State cooperation, in particular from Uganda, has led to a number of arrests over this past year. And in fact, relatively recently. On October 5th, an accused by the name of Adelphonse, Nzeyimana, former second-in-command in charge of intelligence and military operations at the École des Sous-Officiers in Butare, was arrested in Kampala, and he was transferred to the ICTR on October the 6th. He was charged with, among other things, having sent a section of his soldiers to the home of the former Queen of Rwanda and ordering her execution, and she was indeed executed during the genocide. He is also said to have known, or had reason to know, that Tutsi women were being raped before being killed by individuals under his authority, for example, at the roadblocks set up during the genocide. Now, more recently, on June the 30th, Jean Bosco Uwinkindi was arrested in Kampala and transferred to the ICTR on July the 2nd. He was the former pastor in charge of a church in Kigali Rural Prefecture, and he's charged with leading a group to exterminate Tutsi in his own church, as well as elsewhere. And on July 9th, he entered a plea of not guilty, so his case is being looked at by the ICTR. The ICC, subject of a lot of our discussions so far, has seen a number of really interesting positive developments in the field of cooperation. First of all, its network of cooperative states has expanded again because the number of states parties has expanded over the past year. There are now 113 states that have ratified the Rome Statute. On March 23rd, Bangladesh joined the ICC. On August 10th, the Republic of Seychelles. And on August 18th, St. Lucia joined the ICC. And I think this is very positive because there was a while there where we had a number of ratifications, a large number, and then we had a sort of drought in ratifications. So now it seems to be picking up again, and that is very positive. And I must say that especially with respect to the last one, St. Lucia, Bill Pace's organization, the Coalition for an International Criminal Court, was quite instrumental in getting St. Lucia on board. So civil society is absolutely key to getting these ratifications. The second positive breakthrough is in cooperation by a non-state party, the United States. Many of you heard Stephen Rapp last night, and he reiterated the United States' new policy of positive engagement with the International Criminal Court. I was at the Assembly of States Parties for the International Criminal Court. This is an annual gathering of all the states that have ratified the Rome Statute, and they adopt a budget and they do many other things. And this is where Stephen Rapp came and gave a statement about this new positive engagement with the ICC. And I felt very heartwarmed by it, because I had been there in 2000 when the United States withdrew from the process, and it was a very acrimonious sort of withdrawal under the Bush administration. And to have this very cooperative attitude displayed by Stephen Rapp was, I thought, a very, very wonderful breakthrough. So what Stephen had to say there, and in the review conference, and again last night, is that the United States is willing to consider ICC cooperation requests on a case-by-case basis. This kind of cooperation can be done in a number of ways. The United States can make supportive political or diplomatic statements. The United States could share information with the ICC, or could provide witness assistance to the ICC. The third development with respect to cooperation at the ICC is that at the review conference there's this very intriguing initiative to strengthen cooperation, where states and the European Union issued pledges with the purpose of exhibiting cooperation and strengthening the Rome Statute system. There were 112 pledges made by 35 states parties, as well as the United States and the European Union. These ranged, they were all kinds of pledges. So they ranged from pledges to adopt ICC implementing legislation, which if they were a state party, they probably already should have done, but they haven't all done, so it's positive that they will do it soon. To conducting training or seminars at the national level to raise awareness about the ICC or educate about the ICC. Or entering an agreement with the ICC on the relocation of witnesses, that's positive. Providing technical or other assistance to states to help other states ratify the ICC. Also, quite a few pledges of money to the ICC's Victims Trust Fund. The fourth positive development on cooperation also came from the review conference, and that was a resolution on strengthening the enforcement of sentences. This was brought to the floor at the initiative of Norway. Now, why would Norway do this? Well, the resolution recognizes that there are some states that would really like to serve as states in which ICC convicted persons could serve their sentences, but they simply do not have the prison system that meets the international standards that are required under Article 103 of the Rome Statute. So what Norway put forward was the idea that some states could assist states or international organizations could assist those willing states to help get their prison system up to the required international standards. And in doing that, we could have a more geographically diverse set of states willing to accept ICC convicted persons. The reason why we need to have more geographic diversity is because right now there are sentence enforcement agreements with the ICC with Belgium, Denmark, Finland, Austria, and the United Kingdom. But the cases before the court right now are in Africa. So if we could get states in Africa that are able to accept ICC convicted, then individuals could serve their sentences closer to their home state. They can be closer to family. I'm going to turn now to the opposite theme of non-cooperation. Just over this past 2 months, we have had several examples of non-cooperation with respect to the International Criminal Court. On July 12th, so not too long ago, the ICC's pretrial chamber issued its second arrest warrant against Sudanese President al-Bashir for for 3 counts of genocide carried out in the Darfur region of Sudan. The previous arrest warrant was from 2009, and that was for 5 counts of crimes against humanity and 2 counts of war crimes related also to the events in Darfur. Just over 1 week later, Chad, which is a state party to the International Criminal Court statute and which has an obligation to arrest those who are subject to arrest warrants, warmly welcomed President al-Bashir from Sudan into Chad. He was not arrested, and as I mentioned, in fact, he was warmly welcomed. This lack of cooperation by Chad is very troubling. On June 3rd, the Attorney General of Kenya wrote a letter to the chairperson of the Commission of the African Union. He wrote it on behalf of all of the African states that are party to the International Criminal Court statute. There are 31 of them, and they are the largest bloc of states in the world. This letter was asking that the African Union expedite the establishment of a liaison office for the International Criminal Court at the African Union headquarters in Addis Ababa. And this African Union liaison office with the ICC had been approved earlier in November by the Assembly of States Parties. So that's on June the 3rd. But on July 29th, the African Union Summit issued a document. I should mention this African Union Summit took place in Kampala not too long after we had our ICC review conference. So at this African Union Summit, they issued a document, all the African states issued a document that reiterated the decision of the African Union to not cooperate with the ICC on the arrest of President al-Bashir of Sudan. And also the summit rejected the request by the ICC, for now, to open a liaison office to the African Union in Addis Ababa. So this is puzzling at best, because if 31 African states are members of the ICC, they're also members of the African Union, and yet the African Union Summit document is meant to convey all of the African states' views. Where are the views of the ICC supporter states? I should also mention that this document was really strange. It included a paragraph that said that the African Union condemns the unacceptable, rude, and condescending statements made by the prosecutor of the ICC on the case of Sudanese President al-Bashir. Now, I'm not exactly sure what statements they're referring to. It's good to know that the Sudanese government is listening to the statements of the ICC prosecutor on the Sudan case, on the al-Bashir case. But it seems to me that this statement in the African Union Summit document is part of an ongoing information campaign by the Sudanese government to distract everybody from the mass atrocities in Darfur to make itself look like a victim of the ICC's attention. The injured victim. I think the explanation of why ICC states parties went along with this is simply to do with power politics of the Sudan and perhaps Libya. I wanted to also mention that while this African Union Summit document looked like a document coming out of the entire African Union, Botswana, for example, stated only 2 days before the adoption of this document that it would not disregard its obligations with respect to the ICC. So we have a dissenting voice in that. Clearly, the summit document was not a unanimous opinion. There was one other thing that came out of the African Union Summit document that I just wanted to point out here. In the document, it said that African states should continue to press for the amendment of the ICC statute, a particular article called Article 16. Article 16 provides the renewal of, a possibility of a renewable deferral by the UN Security Council of an ICC investigation or prosecution for 1 year. So let me just give you a little bit of background to this discussion of amending the ICC statutes, Article 16, which allows for this removal of an investigation or a prosecution from the docket of the ICC for a year, which is renewable. In the previous November, in November 2009, those of us who were at the Assembly of States Parties had to decide what we were going to discuss at the review conference. And we had a number of proposals on our plates, one of which, of course, was the crime of aggression, that was for sure going towards the review conference. But we had other amendments, for example, to add the crime of terrorism to the Rome Statute, to look at drug trafficking, and the African Union proposal to amend Article 16. And what they proposed was that Article 16 would be amended to allow, if the Security Council did not decide to defer a particular matter at the request of a particular state with jurisdiction, then that state could ask the UN General Assembly to assume the Security Council's power to defer. So this is one of the proposals that we looked at. Should we send it to the review conference? Should we not send it to the review conference? And I can tell you that South Africa introduced this proposal on behalf of the African Union, but it did it with very little enthusiasm. And there was very little African support amongst the ICC states parties for this proposal to go forward, and it was rejected from going forward and not considered at the review conference. However, in a typical diplomatic move, and I was on the Canadian delegation, so partly to blame, I suppose, the diplomats just put off the decision on what to do with all these other proposals. And they said, we'll consider what to do with them at the next Assembly of States Parties meeting. That happens in December 6th to 10th, I think it is. And it could be as early as December that we're faced again with this proposal from the African Union to try and get an expansion to this power of deferral or removal of investigation and prosecution from the ICC's docket. This again is at the instigation of Sudan. In the latest development, which is only just this past week, on Friday, President al-Bashir visited Kenya, another ICC state party, and in fact, a country under investigation by the ICC. President al-Bashir visited Kenya to celebrate the adoption of the new Kenyan constitution. This time, the ICC reacted. The ICC's pre-trial chamber issued a report to the Security Council and the ICC's Assembly of States Parties about the Chad visit and about the Kenya visit, and asked for action as appropriate. And Bill Paste has told me that yesterday, the latest development in this saga is the African Union responded, and Bill, correct me if I get this wrong, and said, how dare the Security Council or the ICC Assembly of State Party try and force the African Union countries to go against their own African Union summit declarations. Is that right? So this is an ongoing tit-for-tat issue on cooperation and the ICC. Still on cooperation, I wanted to mention one very particular, very interesting and thought-provoking report that came out since the last dialogue. It was called 24 Hours for Darfur. And a number of organizations interviewed more than 2,000 Darfuri refugees on the Chadian side of the Sudan-Chad border. The study was titled Darfurian Voices, Documenting Darfurian Refugees' Views on Issues of Peace, Justice, and Reconciliation. And what I wanted to bring to your attention was the survey indicated that 87.5% of the interviewees said that the government of Sudan, or President Bashir specifically, were the root cause of the conflict in Darfur. And 98% of all those interviewed thought that President Bashir should be tried before the ICC. Finally, before I turn to my theme of closure, I wanted to highlight one absolutely crucial aspect of cooperation, that of the witnesses who come before the tribunals to tell their stories, often at great risk to themselves. The Special Court for Sierra Leone was given a great deal of press attention recently over the appearance of supermodel Naomi Campbell. While I think it was gratifying that there was quite a bit of press attention on the Special Court during that time, and finally paid to the very fascinating case of Charles Taylor before the Special Court, it's really easy in the Campbell spotlight to forget that the story of the connection of conflict diamonds to Charles Taylor and the RUF largely came from civilians and insiders on the ground in Sierra Leone or Liberia during the conflict. And that's not something that Naomi Campbell would talk about. She was not on the ground in Sierra Leone. She did not see the atrocities or experience the atrocities. Over the past several months, the ICC's Lubanga trial, which is focused on charges related to the recruitment and use of child soldiers, has raised awareness within the international criminal law community on the importance of intermediaries. Now, I just explained earlier what intermediaries are, but those are, again, non-ICC employees who locate or act as go-betweens, potential witnesses in the field on behalf of the Office of the Prosecutor. Now, why did this become an issue? Some of the witnesses who testified at the ICC in the Lubanga trial in The Hague provided accounts that said that intermediaries had made promises to them in exchange for them giving fabricated evidence to the ICC that they had served as child soldiers. This resulted in a decision of the trial chamber on intermediaries, in which the trial chamber ordered the disclosure of the identities of those intermediaries, including one that went by the acronym P143, pending protection measures being put in place for the disclosure of their identity. And on 8th of July, the trial chamber granted a stay of proceedings in the Lubanga case on account of the prosecutor's failure to comply with this decision. Now, you heard an explanation of it yesterday from Fatou Bensouda. But having read through that decision, the argument of the prosecutor at times is quite puzzling, in my point of view. I'm not sure what others think. And it's not surprising that the prosecutor's argument was not accepted by the trial chamber. But it sounds like the stay of proceedings will come to an end soon, from what Fatou had to say. And thankfully that the case will go on. Turning to my final theme, which is that of closure. The ICC is a permanent institution, so it doesn't have to worry about a lot of the things that the time-limited ones do. The ICTY, the ICTR, and the Special Court for Sierra Leone will all be closing down relatively soon. The Special Court will be the first one to close down in 2012. The next ones will be the ICTY and ICTR around 2014. And I should mention here that the Cambodia Tribunal and the Special Tribunal for Lebanon are also time-limited. And in theory, they are supposed to have completed their proceedings within about 3 years of their opening, which would put their closure date at 2012. But in reality, that will be extended, assuming the Special Tribunal for Lebanon gets some cases. Now, the closure of these tribunals raised a number of legal and practical issues. For example, after you close a tribunal down, what happens to all those witnesses that had been protected by the tribunal prior? You can't just padlock the door and walk away and say, good luck, witnesses, hope you stay alive. You need to continue that protection. Who's going to do it? What is going to do it after the tribunals close down? Also, who is going to preserve and protect the archives? If some of those archives, which contain protected victim names in them, just got out on the street, the victims whose names had been previously protected could be killed in retaliation for their evidence. Who's going to monitor the imprisonment of those who have been convicted by all of these different tribunals and are serving sentences at various prisons around the world? Well, it's going to be something which in a very dry legal name is called a residual mechanism. I'm sorry, it's a very unsexy name, but us lawyers don't always come up with the best terms. So something called a residual mechanism is going to be established that will succeed these tribunals and take over these particular duties. One of the most important duties that it will have, too, is tracking fugitives. So in the International Criminal Tribunal for Rwanda especially, there are a number of fugitives that could remain on the run after the closure of the ICTR. There's still an indictment out there, they still should face justice, and so they need to be tracked, and if they're arrested, there needs to be a body that can try them, and that would be this residual mechanism. Okay, so what's happened over the past year in the creation of these residual mechanisms? Well, the Special Court for Sierra Leone, because it's closing soon, has had a plan in place for quite some time about how it's going to move towards closure. It's been steadily implementing this plan over the past year. So for example, after the finishing of the final trial in Freetown, work has been going on to close portions of the court out in Freetown. So in October of this past year, 8 people who had been convicted by the special court were transferred from the detention facility there to a prison in Rwanda, where they're now serving their sentences. That allowed the special court to close the detention unit and hand the keys over to the Sierra Leone Prison Service. That happened in mid-November. Sierra Leone's Director of Prisons indicated that this new facility, which they're now in possession of, will be used to house female prisoners. Also in November, the special court launched a month-long training program on witness protection with Sierra Leonean police. The idea is this: if the Sierra Leonean police can gain more experience in witness protection through the assistance of the special court, then over time they can take over the witness protection after the special court closes. The special court has committed to providing its own direct witness protection for 5 years after its closure. But hopefully, after those 5 years are up, the Sierra Leonean police will be in a position to take over that witness protection. Also, Sierra Leone and the United Nations have entered into an agreement about the closure of the special court and the establishment of its residual mechanism. And the agreement has the idea to send all of the archives, the original archives, to The Hague for storage and keeping up, and have copies, public copies, in Sierra Leone. Now, the ICTY and ICTR have been preparing for closure a bit differently. This is because these are 2 tribunals created by the Security Council. So the Security Council is the one that has to adopt a resolution that says how they're going to close down and what is going to come afterwards. So there's something, again, a very lawyerly term. The Security Council's informal working group on international tribunals has been considering this issue over the past year. It's for a bit longer, but it's really gotten into the meat of it in the last year. And the Security Council, it looks like, is leaning towards the creation of one joint residual mechanism with 2 offices, one in Africa, one in Europe, and the archives will probably be also divided up, kept in Europe, kept in Africa. And this residual mechanism is meant to be small and efficient, but can quickly in UN terms, which is slow to you and I, ramp up to be able to try any fugitives that get arrested from the ICTR after the actual closure of the ICTR. When will the residual mechanism start? Well, the start dates will be different because the 2 tribunals will end at different times. Interestingly, there has also been other discussions, other studies around the closure of the ICTY and ICTR. So for example, the ICTY held a conference in February of this past year about its legacy. It invited people from all parts of the former Yugoslavia, from civil society, to assess and evaluate the legacy of the ICTY. And in a shameless plug, I will also mention that my law school arranged a conference, an expert group meeting at a permanent mission of Canada with the Canadian mission and the International Centre for Transitional Justice to look at residual mechanisms for all of these different tribunals. So there's been thinking going on outside of the Security Council with the intention that this thinking would pressure the Security Council in acting more quickly on figuring out what it's going to do after these tribunals close. I just wanted to mention here too that the closure of the tribunals is not as easy as it might sound. Okay, yes, we established this residual mechanism, we task it to be able to take on different responsibilities, but from a legal point of view, you have to ensure that there's absolutely watertight continuity of jurisdiction from the tribunal to the residual mechanism. After all, there could be legal challenges in the residual mechanism by lawyers saying a different body made the indictment for this person, and now this body is trying this person. You need to show that they are legally, in some respects, one and the same thing. The other challenge being considered by the Security Council is, what do you do if someone like Mladic is arrested with 1 month to go before the end of the ICTY? All the plans have been put in place, everything has been going on to close that tribunal down, and suddenly 1 week to go or 1 month to go, Mladic is arrested and sent to the ICTY in The Hague. Should you simply extend the life of the ICTY and try him? Or should the residual mechanism be immediately created and then he starts being tried in the residual mechanism, which will run alongside the actual ICTY before it's closed? What happens with the appeal? If you extend the life of the tribunal, should you also extend the life of the trial of the appeals chamber? Or should the tribunal simply go on for as long as it exists and then transfer the trial over to the residual mechanism? So these sorts of very tricky questions need to be dealt with by the Security Council before it adopts, hopefully later this fall, a resolution on the ICTY and ICTR residual joint mechanism. I wanted to point out one of the major difficulties. It came out in the comment by the ICTR prosecutor yesterday, associated with the closure of these tribunals. If you were working for those tribunals and you saw that they were about to close down, wouldn't you be looking for work? You probably would, right? And if the opportunity came up, you would go, even though that tribunal is not yet done. And this is what's been happening at the tribunals. The ICTY's President Robinson outlined the depth of this problem. It's a very, very serious problem with the tribunals, this attrition problem. And here's what he had to say. He said this to the Security Council. Staff attrition and the desperate need for urgent action in stemming that flow is a factor that I have repeatedly stressed to the utmost degree in my previous presentations to the Security Council and the General Assembly. I am quite frankly at a loss as to what more might be done or said on my part to turn your attention to this issue. Staff are leaving the tribunal in droves, 3 in every 5 days, for greater job security with other institutions, mostly within the United Nations. I must therefore warn you that this factor is impacting adversely on our expeditious completion of all but one of our trials, and it will worsen. Our trials will be further delayed by staff attrition. What he's talking about are senior staff members that have that institutional memory, that have that depth of knowledge about the particular cases, are leaving to take on positions with job security. This is because he has made the appeal, previous presidents have made the appeal to the Security Council and the United Nations General Assembly. Please do something to stop this to stem this flow. Please, for example, put in place contracts where they're rewarded for staying till the end, where they will be given a bit of money at the end so that they will know they've got 3 or 4 months to look for a job afterwards, where they don't have to worry about where their salary is coming from. But the United Nations has not done that yet. And I'd like to thank Diane, who's in the audience somewhere, for pointing this out on the In Law Girls blog recently. very, very important ongoing problem that could have been averted a long time ago. Okay, so I have just given you a whole bunch of bad news. Let me talk about the Special Tribunal for Lebanon in the frame of good news. It has learned lessons. It has seen what's been going on about the closure of the ICTY, the ICTR, and the Special Court for Sierra Leone, and it is trying to learn lessons from their experiences by planning from the beginning of its establishment for its eventual closure. So, for example, over this past year, it has worked on a tribunal-wide information management policy to manage information in a way that makes sense now and makes sense when the archives are turned over to a residual mechanism. Now, I know this sounds probably really, really dry, but if you think about what's in these archives, there are physical specimens, skulls, for example. There are papers, lots of papers. There are electronic documents. There are emails. There are exhibits. There are all kinds of things in these archives. And when the ICTY and ICTR especially were created, there was no idea given to classifying these in certain levels such that after a certain period of time, certain of the documents could become public. And now they're scrambling to go through all of the archives and figure out what to keep, what not to keep, what to classify, what's public, what's not public. And the STL, the Special Tribunal for Lebanon, is doing that from the beginning. It will make closure a great deal easier, but it will also make the job of the archivist a great deal easier as well, to keep the archives up over time. Okay, I am ending. I've taken you through a whirlwind tour of my three themes: review, cooperation, and closure. I hope that my comments have highlighted that there are certain key developments in the field of international criminal law over the past year that relate to these three themes. But I hope that you also see how interconnected international criminal law is. That international criminal law is facing old issues and new issues every day in a very complex manner. Key to the ongoing development of international criminal law, in my view, is the growing availability of information about the workings, the internal workings, of these tribunals. The Nuremberg tribunals were recorded in newspapers. Now we have the internet, so we've got the ICC's website, and all the tribunals have websites. But we also have ICC and ICTY weekly updates by email. We've got the Twitter feed from the Special Court for Sierra Leone. We have non-governmental websites that follow on a day-to-day basis the evidence brought forward at trials, like CharlesTaylorTrial.org, LubandaTrial.org, CambodiaTribunal.org, and the Special Tribunal for Lebanon Monitor. But we also have international law blogs, like Opinion Juris in Law Bureaus that I just mentioned before, and IHLD Talk, which is the European Journal of International Law Talk, among many others. And all of these serve to increase the transparency of the tribunals and the public interaction with the tribunals. So not only legal practitioners like myself who specialize in these tribunals can follow what's going on, but you can follow what's going on. You can understand what's going on. Let me give you one example. CharlesTaylorTrial.org has not only a summary of what happened each day in the trial session that makes it infinitely easier to understand how the trial is unfolding, but if you scroll down below, you'll see tens of, or if not up to hundreds of comments by Sierra Leoneans and Liberians in Sierra Leone, in Liberia, and in the diaspora, debating from very, very different points of view the Charles Taylor trial. And it's that conversation that I think is very important for international criminal law. So I'm going to end here and say that the dissemination of the results of things like this, the international humanitarian law dialogues, are one more additional key to this field. I look forward to next year's review of the 2010-2011 year in international criminal law, and I hope it contains more good news than bad about review, cooperation, and closure. Thank you.